Good afternoon, everyone, and thank you for joining me for the February edition of the Michigan PIP Monthly, which is a Secrest Wardle broadcast providing you with monthly updates in Michigan no fault, specifically focusing on updates in first-party law and different topics of conversation that we've seen going on in the courts, Court of Appeals, or just our day-to-day litigation. For the February 2018 podcast, we're going to talk about a few different things. The first one being a discussion about provider trials and the admissibility of the certificate of need. For those of you that handle a lot of provider cases, you're probably familiar with the fact that there are certain hurdles, especially in the district court, where you're more limited in what you can do at trial, and just you're basically on the whim of the judges there very often. And often that includes getting in key documents to support your defenses, including the document of the certificate of need. So I'll talk a bit about the arguments that we've seen raised in these provider trials, our responses to them, and provide you with some perspective as to what the judges are ultimately ruling, what the plaintiff attorney argues, and how you can try to overcome those hurdles at trial and get that evidence in and before the jury. The second topic I'll be addressing today is about the case of Shelton versus Auto Owners, which came down about 8 months or almost a year ago, actually. And Shelton discusses fraud of a claimant who is not a policyholder, but still nonetheless is making a claim under the policy. Shelton and Bahri are typically used to attempt to dismiss certain cases, but Shelton is often used by plaintiff attorneys, arguably incorrectly, to survive a Bahri motion. So I'll go through the arguments as to both sides and give you some information as to how you can respond to the Shelton arguments often raised by plaintiff attorneys, either in pre-suit or if the case is in litigation, how you can overcome that or work with your counsel to overcome that in dispositive motion hearings. The next topic that we would be discussing today is the Court of Appeals update, which will discuss the application of the parked vehicle exclusion in the case of Taylor versus Frankenmuth. There really was not too many cases in the Court of Appeals, at least in PIP law, that came down in the month of February, and quite frankly, this is the only one that has really come down that addresses some key issues here. So I'll go through that case as well and provide you with an update as to the Court of Appeals. Now, when thinking about provider trials and provider cases generally, in this day and age, post-covenant era, we do have to initially address, where we stand post-covenant before we even begin to litigate a provider case or handle a provider claim pre-suit. And what we've all come to find out in the several months following covenant is that many judges are doing different things despite the covenant holding. Obviously, we've all seen the assignments of rights that are being attached to complaints or attached to motions or responses to motions for summary or in motions to amend the complaint. And more often than not, the judges are allowing the providers to pursue their claims so long as they had the assignment. Now, what that results in is the claim proceeding in course, and the providers are able to maintain their claims against the insurance carriers. So I've personally seen a handful of judges in Wayne County grant the covenant motions, oftentimes without prejudice, which causes some other problems down the line if you're dealing with the claimant directly. But, the judges nevertheless are kind of doing their own thing with regard to whether or not they're going to grant covenant motions. So you're ultimately left with having to rely on your usual defenses in provider cases, despite the newly raised covenant issues, but the long-standing argument that these providers never had standing to sue a carrier under the No Fault Act. But covenant aside, our primary defenses in a provider case are, of course, whether or not the service was reasonable and necessary, and whether the charge itself was reasonable. And often with these provider cases in particular, we see a lot of high-priced MRIs, sometimes $5,200, dollars for an MRI, or we see a lot of this, blood work testing or urine sample testing that is just truly racks up an extreme amount of bills by these providers. So you've got to not only, run through the bills, determine if they're reasonable rates, but you adjust the claim and assess whether or not the charges are reasonable. And oftentimes you're going based off, at the claims level, you're going based off of, documents that you've seen in the past, your review and adjustment of claims. Your provider may particularly use, Corvell or Mitchell to determine the UNC rate for these kinds of services. Now, oftentimes that creates a hurdle for us at trial, because the plaintiff attorney will, of course, file a motion saying that, Corvell rates and Corvell or Mitchell rates are not admissible and that they're based on hearsay. And, I've seen and heard of other attorneys or other firms having that kind of evidence stricken from the provider trials in and of itself. And the judges tend to find that, unless you have someone who's going to come in live and testify from Corvell or from Mitchell or from another company that you use as to how exactly they calculate the UNC rate and what is the basis for determining that a certain amount of rate is reasonable, then that the evidence is not going to come in. And what we do in those situations is we will hire an independent bill review expert to review the billing and to be able to come in live or come in via video at trial and provide the jury with evidence that is not hearsay about what the typical charges for an MRI is, or a therapy procedure, or again, the blood work procedure that we're seeing very often in these PIP cases. But you certainly do have to overcome the hearsay hurdle before you even get to the jury, before you even begin your case, because oftentimes these things are dealt with as a motion in limine. But what you can try to do or try to bring in as evidence is what's called the certificate of need. What is a certificate of need? A certificate of need in the U.S. is a legal document required in many states to be filed with the state of Michigan, and sometimes even filed with the federal authorities before any acquisition of a business or expansion or even the creation of the facility is allowed. So essentially, if you're trying to start a business, you have to provide, a plethora of documentation. These certificate of needs are usually about 400 to 500 pages, outlining your business plan, outlining what you intend to charge the community, and outlining exactly what type of services you are providing. These certificate of need programs are aimed at restraining healthcare facility costs and facilitating coordinated planning of new services and facility construction. Now, if you dig through the 400 and 500 page certificate of needs, as I've done, and I know my colleagues have done as well, you will be able to find a chart of projected charges for the services rendered. And it's pretty buried in what's called in the certificate of need, but is located in the general financial questions of the business. And, as a standard form, you'll see in there what this carrier or what this provider, is going to charge Medicaid, what they're going to charge Blue Cross, what they're going to charge Blue Cross, and finally, what they're going to charge private pay carriers or other carriers. And in the certificates of need that I've personally seen, this is a flat number across the board. They don't disclose, of course, to the state of Michigan that they're going to be charging Medicaid something different than they're going to be charging Blue Cross. These often also don't disclose that they'll be charging no-fault carriers a certain rate and claimants who walk in off the street a certain rate. Instead, these charges typically are one figure across the board. For example, a provider MRI facility will list in the certificate of need financial question statement that they will charge $700 per MRI for Medicaid, Medicare, Blue Cross, and private pay. No disclosure of any increase of rates depending on whether or not you're an insurance carrier, whether you're a no-fault carrier, whether you're a Medicare participant, or if you're a claimant walking off of the street. Now, this is interesting because, in our investigations as to the reasonableness of charges, we've called facilities that we see often in litigation, of course, never during the course of litigation, and various SIU people will do the same and find that, they're charging $300 for an MRI, or they'll even advertise that they're charging $250 for an MRI. Yet, of course, when the bill gets to the insurance carrier's desk, there's a $5,200 charge for the exact service that was advertised as $250 to $300 per MRI. Now, how do you get all this good stuff in at trial? And how do you present this effectively to the jury without having counsel say that it's inadmissible hearsay? Now, of course, you have to subpoena the facilities for the certificate of need or subpoena the state of Michigan to disclose the certificate of need. And you'll get all of that documentation and parse through it. As you approach trial, you'll face challenges from the plaintiff attorney saying that the certificate of need is not admissible. And we've seen them. I've gathered a lot of the arguments that are raised, and essentially the primary argument that we see is that the certificate of need is a state regulatory program intended to ensure that only needed services are developed in Michigan. The department then provides a pro form application to the facility, and plaintiffs will argue that at that point of submitting these forms, there's no actual or real costs because it's only a projected idea of what these services will cost. Again, the argument is essentially that the certificate of need is merely a projected or estimated financial statement that is an attempt to provide an accurate idea of the firm's financial abilities and what they'll eventually charge. Now, I've also seen the argument that the only purpose of the certificate of need is to determine whether or not the construction of an MRI facility in a certain area is viable. In other words, the certificate of need is used by the state to approve licensing by these providers by determining, do you have too many MRI facilities in that area? Are you going to charge the same amount, or are you going to essentially increase your prices and cause your own business to shut down, and ultimately resulting in, a vacant building in the city or layoffs and all of that kind of stuff? It's more of a social economic kind of projection. From a legal standpoint, the argument is that the certificate of need is speculative, that it contains hearsay, and it's not probative as to what the actual charges or reasonable charges are going to be. Now, that is all something that we have to address before it even comes in at trial. And as an initial matter, just a quick overview of what hearsay is. Hearsay, by definition, is an out-of-court statement offered to prove the truth of the matter asserted. So to say that a document is hearsay means that the information contained in the document contains information that is obtained outside of court. There's no one to testify as to its contents, to authenticate its contents, etc. However, there are exceptions to the hearsay rule, and among those exceptions is in Michigan Rules of Evidence 803, which is records of regularly conducted activity. So on the defense side, when a plaintiff attorney argues that the certificate of need is not admissible, then we respond and say that no, this is a business record kept in the regular course of activity. And by definition, if a business record is kept in the regular conducted business activity, and if it was the regular practice of that business activity to make the record, then it is admissible under the rules of evidence. That being said, what we argue is that the certificate of need is a business document kept by the plaintiff in a case, or just in the regular course of their business. It is a self-authenticating document submitted to the state of Michigan in order to become a licensed provider operating in the state of Michigan. So we argue that since the plaintiff represented to the state of Michigan that it would charge a sum stated for MRI services to obtain its licensing, then it is certainly admissible to present to a jury what they said they would charge to obtain their licensing and to keep their licensing in good standing. Moreover, the provider's license to operate in the state of Michigan was approved based on the contents of the certificate of need, and particularly based on the representation that it would charge only $700 or however minimal amount for an MRI. And despite that, you argue that they represented one thing to the state of Michigan, yet they're charging the insurance carrier more than oftentimes 10 times the amount for those services. Now, all of that goes to the fact that the certificate of need information bears on the reasonableness of charges provided to a provider. And of course, we all know that a defendant or an insurer under the No-Fault Act is not only entitled to assess charges for reasonableness, but they are required to do so. The No-Fault Act requires an assessment of reasonableness of costs in claim handling. While there are no published cases or any real cases that I've seen in the Court of Appeals or the Supreme Court addressing the admissibility of the certificate of need, there was a recent case of Bronson versus Auto Owners, a 2012 decision where the carrier was seeking the wholesale cost of products. And so what we argue is that the certificate of need contains the actual charges that it'll say to the patient. So if the court in Bronson versus Auto Owners determined that the wholesale cost of products is certainly discoverable for the purpose of adjusting a claim and determining whether charges are reasonable, then it must be the case that the actual charges that were projected to be charged for MRI services is also admissible. Now, different judges are going to do different things on this, but this is certainly an avenue to explore both in litigation and pre-suit as well. So if you have the figures of the certificate of need and you've reviewed them in the adjustment of your claim, you can tell the provider that you've reviewed various documentation and it appears the charge for this amount is X. Arguably, you can even provide them with their own certificate of need in the adjustment of the claim and say, here's what I'm willing to pay, not $5,200, but $700. Please accept this as full and final payment for this service. And that is an effective way at the claim stage to respond to these excessive charges. And then it sets you up for litigation for you to bring this in at trial because it was part of your claim handling, and you will testify to that fact, making it admissible and ultimately overcoming the hearsay hurdle. If you want more information about the certificate of need, or if you're looking for particular certificates of need by different providers, please contact me and I can get you that documentation. We keep a pretty hefty bank over here of different certificates of need and are happy to share those with our clients. So now we've talked at length about the certificate of need in provider suits. Let's kind of shift our focus and discuss the claims of a first-party claimant. Now, if you're listening to this podcast, it's safe to say you're probably very familiar with the Bahri versus IDS case, which was a 2014 case that has kind of teed us all up to get cases dismissed for material misrepresentation or fraud, which we've always made those arguments, but the court truly provided a very solid analysis in Bahri for the dismissal of fraudulent claims. And just briefly, Bahri was a first-party case in which the plaintiff sought medical expenses and household services, and there were numerous providers involved in that lawsuit as well. Ultimately, the defendant produced surveillance depicting the plaintiff performing activities that were inconsistent with her claimed limitations. Specifically, the claimant was observed lifting, bending, carrying objects, running errands, and driving on dates when she specifically claimed she needed help with those tasks. So ultimately, the court concluded that the evidence directly contradicted the plaintiff's assertions. As a result, the court found that reasonable minds could not differ that the plaintiff made fraudulent representations for the purpose of recovering first-party benefits. And because the plaintiff's claims were precluded, the intervening provider's claims were barred as well. Now, what's key about Bahri, and it becomes more evident as to why that's key in Shelton, is that Bahri involved a named insured, a person named under the policy that has a direct contractual relationship with the insurance carrier. Now, things got a little tricky after Bahri when people started filing a lot of motions on the basis of Bahri, whether or not the person was a named insured or merely a person seeking payment under the priority scheme of 3114. In other words, the claimant was not a contractual party to the insurance policy. In Shelton versus Auto Owners, the plaintiff was injured while a passenger in a motor vehicle owned and operated by a man named Timothy Williams. The plaintiff did not own a vehicle, nor did she reside with a resident relative who owned a vehicle. That being said, driver Williams' insurer was the highest in priority for payment of first-party benefits under 3114. The claimant sought payment for medical expenses and household services and filed suit following the denial of those benefits. Now, in Shelton, throughout the course of litigation, the defendant obtained surveillance of plaintiff, which depicted plaintiff performing activities inconsistent with her alleged limitations. Again, this factual scenario is identical to Bahri. Defendant argued that the policy exclusion applies to plaintiff despite the fact that she was not a policy holder. The appellate court disagreed with defendant's contention that Bahri was legally and factually similar to this Shelton case. The court determined that the exclusionary provision in defendant's no-fault policy does not apply to the plaintiff and could not operate to bar the plaintiff's claim. Specifically, unlike Bahri, the subject case involved a plaintiff that was not a party to nor an insured under the policy of insurance. Instead, defendant was required to afford first-party benefits to the claimant or plaintiff under 3114. The appellate court used MCL 500-3114 subsection 4 to argue that the plain language of the statute does not require an application of the policy terms to the particular plaintiff. In other words, the difference between Bahri and Shelton is that Bahri involved a named insured or a policyholder. Shelton did not. Shelton involved a claimant that was seeking first-party benefits under the priority scheme listed in 3114. That is a key distinction because the defendant argued that the policy language is what excluded the benefits. Now that we've made the clear distinctions between Shelton and Bahri, again, Bahri, named insured, Shelton, not a named insured. What are we seeing when we handle these claims? We're seeing the plaintiff attorneys using Shelton to say that you cannot argue Bahri, you cannot argue any kind of Bahri analysis, and I've even seen plaintiff attorneys go as far as to say that you can't argue material misrepresentation in cases where the claimant is not a named insured. But that's not true. And when you look at Shelton closely, and you pull the case law that the Court of Appeals cites in Shelton, it's clear that the ruling does not preclude no-fault insurers from denying fraudulent claims. Shelton truly held that you simply cannot argue that the policy language precludes the claim. You certainly can still argue the elements of fraud and adjust the claim accordingly based on the fraud. Now, the court specifically said that it has long been held that insurers are afforded an opportunity to review claims for lack of coverage, for excessiveness, and for fraud. And the court cites Advocacy Organization for Patients and Providers versus Auto Club Insurance, a 2003 case that sets forth that assessment of fraud and an insurer's obligation to adjust claims with these type of lenses on if necessary. Now, this kind of argument is one where you've got to have the court look at the forest through the trees. And a lot of times, the court, especially if it's a judge that's not very familiar with the case law, will listen to those arguments and say, okay, well, Shelton does say that you can't argue Bahri because of the fact that the person is not a named insured. But in response, you would argue that it doesn't stop there. The analysis doesn't stop there. And that there's long-standing case law and reaffirmed in the Advocacy 2003 case saying that insurers are necessarily required and entitled to adjust these claims for coverage, for excessiveness, and for fraud. Bahri didn't provide, an end for carriers to assess whether or not there's fraud in a claimant's first-party claim, either at the pre-suit level or in litigation. So if you are presented with the Shelton response, quote unquote, by plaintiffs in a pre-suit level, let's say you're dealing with a plaintiff attorney pre-suit, you're going to want to say that Shelton doesn't say that I cannot adjust a claim for fraud. Shelton doesn't say that I cannot adjust a claim for any kind of excessiveness. Instead, Shelton merely says that you cannot argue that the policy language itself is what precludes the claim, but you can certainly argue the elements of fraud and still bar the claim or authorize your counsel to file a motion for summary disposition based upon this long-standing ability to adjust claims for fraud. Now, the distinction between Shelton and Bafri has become very important because we've all seen time and again filing Bafri motions or filing these fraud motions and having the exact response cranked out by plaintiff's counsel saying this is not a policyholder, so therefore there can be no fraud as to this claimant. And you need to specifically spell out for the judge what the elements of fraud are, why this case is still able to be adjusted based on fraud, and that Bafri or that Shelton never intended to preclude a carrier from adjusting a case based upon fraud. And once that argument is presented clearly before the judge, you can proceed with your arguments in that regard. Now, the purpose of this podcast, in addition to providing you with some insight into the pre-suit and litigated hot issues that we're seeing on a day-to-day basis, but is to also provide you with the Court of Appeals update very briefly so that you are aware of what's going on in the Court of Appeals, so you can always stay on top of the case law and handle your claims accordingly. Having knowledge of what's going on in the Court of Appeals will assist you in just the day-to-day claims handling, or even once your case gets into litigation, you'll be able to work with your counsel to truly attack these cases based on the updated case law. Now, not too much action in the Court of Appeals this month. Just a noteworthy case to kind of go through is the Taylor versus Frankenmuth Mutual Insurance case, unpublished decision issued on February 15th, 2018, and coming out of the Genesee County Circuit Court, making its way to the Court of Appeals. That case involved the application of the parked vehicle exclusion, which is found in MCL 500.3105, and then the exclusion's 3106. Now, the statute provides that under personal protection insurance, an insurance carrier is liable to pay benefits for accidental bodily injury arising out of the ownership, operation, maintenance, or use of a motor vehicle as a motor vehicle subject to the provisions of the chapter. However, when an injury involves a parked motor vehicle, coverage is generally excluded unless the claimant demonstrates that one of three statutory exceptions apply. So then you look to 3106. Which states accidental bodily injury does not arise out of the ownership, operation, maintenance, or use of a parked vehicle as a motor vehicle unless any of the following occur. It also states, except as otherwise provided in subsection 2, the injury was a direct result of physical contact with equipment permanently mounted on the vehicle while the equipment was being operated or used, or while property being lifted onto or lowered from the vehicle in the loading and unloading process. Now, in Taylor versus Frankenmuth, the plaintiff was pumping gasoline into her vehicle at a gas station and tripped over the hose of the gasoline pump, ultimately sustaining injuries. The plaintiff brought suit seeking first-party benefits, but the trial court granted summary disposition to defendant after determining that the plaintiff's vehicle was parked within the meaning of MCL 500.3106(1). and that no exceptions to the parked vehicle exclusion applied. Plaintiff on appeal argued that although her vehicle was stopped, the parked vehicle exclusion did apply under the circumstances. Further, plaintiff argued that the act of pumping gasoline amounted to an exception under the vehicle exclusion encompassed by 3106. More specifically, plaintiff contended that refueling her vehicle constituted maintenance within the meaning of the statute and was therefore superseded. The Court of Appeals disagreed. The court essentially relied extensively on the published case, a 1982 case of Hurd versus State Farm. In Hurd, plaintiff sought to recover no-fault benefits after being struck by a vehicle while pumping gas, similar to the claimant in the Taylor case. The plaintiff in Hurd had failed to maintain insurance on a vehicle, and the trial court therefore granted summary disposition to the defendant. The Michigan Supreme Court reversed, concluding that the plaintiff's vehicle was parked within the meaning of 3106, and that therefore it was not a vehicle involved in the accident for purposes of the claim. Accordingly, because the plaintiff's vehicle was not involved in the accident, it was irrelevant that he failed to maintain insurance, and he could obtain benefits from the insurer of the vehicle that struck him. The court stated that a parked vehicle is not involved in the accident unless one of the exceptions of the exclusion apply, and it therefore concluded that none did. Fundamental to the ruling in Hurd was that the plaintiff's injuries did not arise from the maintenance or use of the vehicle as a motor vehicle. Therefore, the Heard case necessarily requires a conclusion that pumping gasoline is not the type of maintenance contemplated by 3105. Given that the exclusion applied and plaintiff is therefore tasked with demonstrating that one of three statutory exceptions apply, it was then plaintiff's burden to provide more evidence indicating that her specific facts fell within the exclusions contained in the statute. Plaintiff attempted to say and argue that she tripped because she made physical contact with the gas pump hose as it was being used to load fuel into her vehicle. The Court of Appeals rejected this argument and said that the plaintiff did not have direct contact with the gasoline, so she could not say that she was loading gasoline into her vehicle. Certainly a creative argument, but not one that was going to carry the day for the claimant. So ultimately, the Court of Appeals held that the plaintiff's injuries did not result from contact with the property that she contended was being loaded, in other words, the gasoline, and the Court of Appeals affirmed the decision of the trial court granting summary disposition to the defendant. Now, this case can be used in your parked vehicle exclusion cases as a demonstration and thorough analysis of what the Court of Appeals is doing with these parked vehicle exclusion cases. And while the plaintiffs are, trying to stretch the facts or bend the facts arguably to sustain their claim, the fact remains that they still have that burden of proof to come forward with evidence that the facts contained in their case meet the exclusions. And this case is a good example of why it does not. That concludes the February 2018 Michigan PIP Monthly series. Please contact me with any questions or comments you may have. If you want any of the certificate of needs that I mentioned, again, give me a call or an email. I look forward to having you tune in for the March 2018 Michigan PIP Monthly, which will provide you with some hot topics in the industry and provide you with an overview of recent case law from the Court of Appeals and the Michigan Supreme Court. Thank you.